the court is finding you guilty of counts 1 and counts 2. The court will sentence you to 8 years in count 1. There's an affirmative finding of deadly weapon in count 1.
Welcome to the Court of Justice.
Court is calling 2025 CR 009050, State versus Joe Anthony Thomas. Could I have parties announced?
David McLean for the defense.
And are you Mr. Thomas? Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Thomas, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
That's your understanding, Judge. I have no objection.
And are you proceeding on both counts?
Yes, sir.
All right. Did you review the court's admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
In count 1, you're charged with aggravated assault with a deadly weapon. In count 2, you're charged with unlawfully carrying a weapon with a felony conviction. Those both are second-degree felonies. Range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Thomas, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering these pleas to counts 1 and counts 2, you will be deported, denied naturalization, and not be allowed to re-enter. Did you understand?
Yes, ma'am.
All right. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on counts 1 and counts 2. Punishment in each count is to be assessed at 8 years in the prison. There's a $2,000 fine. In count 1, there's an affirmative finding of deadly weapon. There are no applications. This will run concurrently with 2022 CR 3270 and 2023 CR 11355. Did you understand that to be your plea?
Yes, ma'am.
Defense?
That's our plea, Judge.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to count 1, how do you plea?
Contest.
Count 2, how do you plea?
Contest.
State any evidence to support the defendant's plea.
State's
Your Honor, I reviewed that with my client. We have no objection.
All right. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments, and the court will review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty of counts 1 and 2. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Your Honor, we asked the court to follow the plea bargain. We've analyzed this case long and hard along with the state's counsel. And we're hoping that we can try to get this case disposed of. We just asked the court to call the plea bargain.
All right, then, as previously stated, the court is finding you guilty of counts 1 and counts 2. The court will sentence you to 8 years in count 1. There's an affirmative finding of deadly weapon in count 1, 1355, and there's a $2,000 fine. Is there anything else from either side with regards to sentencing?
Your Honor, I wanted to clarify the cases that, did you say those were being taken into consideration?
I'm sorry, concurrent with.
Thank you, Judge. Yeah, I
Thank
believe
you.
that
Thank
was-
you for the correction.
No, I believe that was what the agreement was.
All right, and so for the record, this cause number 2025 CR 009052 will run concurrently with 2020 CR 3270 and 2023 CR 11355, and counts 1 and counts 2 will run concurrently. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because it's a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we're proceeding with 2022 CR 3270. And 2023 CR 11355. Did you review the document in 2023 CR 11355 entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Joe Anthony Thomas who was placed on deferred adjudication in 2023 CR 11355 for the office on unlawful possession of a firearm by a felon on April 2nd, 2024 for a term of 5 years? Is that you? And in cause number 2022 CR 3270, are you the same Joe Anthony Thomas who's placed on community supervision on April 28, 2022 for a term of 6 years for the offense of possession of a firearm by a felon? Is that you?
Yes, ma'am.
All right, state.
Violation of condition number 1 on or about the 18th day of April 2025 in Bexar County, Texas. The defendant, Joe Anthony Leopoldo Thomas, committed the offense of assault in violation of condition number 1.
And is that the same allegations in both motion?
It is, Your
Then in each motion, how do you plead to that allegation? True or not true?
True.
All right. And cause number 2023 CR 11355, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, ma'am.
Court will find violation of condition number 1 true. And cause number 2022 CR 3270, did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, and sentence you up to 6 years in the prison?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 1? Court will find violation of condition number 1 true. Is there a proposed agreement?
There is, Your Honor. It's to grant the state's motion to revoke the defendant and sentence him to 8 years in prison.
That's our understanding, Your Honor.
All right, Mr. Thomas, what I can tell you in the motion to enter adjudication of guilt, it appears to the court that you have learned nothing. So, in cause number 2023 CR 11355, the court is going to grant the motion, find you guilty, revoke. The court is going to sentence you to 10 years in the prison, give you credit for any time served. This will run concurrent with 2025 CR 009050. There should be no contact with the following persons: Christopher Michael Talamontes, Vincent Bernard Alanis, Joshua Patrick Helton, Rings of Fire Tattoo, and then cause number 2022 CR. Oh, and I'm sorry, this is also to run concurrent with 2022 CR 3270. And cause number 2022 CR 3270, the court is going to revoke. The court will sentence you to 6 years in the prison, give you credit for any time served. This is to run concurrent with 2025 CR 009050 and 2023 CR 11355. And there's to be no residing with minors and no unsupervised contact with minors. In each of those cause numbers, did you review the trial court certification of defendant's rights to appeal with your attorney? Did you understand it and did you sign it? All right. In each of the cause numbers, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you are on deferred adjudication or community supervision. Because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, yes.
Just briefly, just for my client's verification, and I know the court's probably already done this, but in each of those cases that we heard here today, my client wants to ensure that he's getting credit for the time that he's already served.
Yeah.
And at any time when he's running concurrent.
Yes.
Thank you very much, Your Honor.
All right, thank you.
Excuse, Your Honor.
Yes.
Thank you very much.
The atmosphere in Judge Stephanie Boyd's courtroom is tense as the case of Joe Anthony Thomas is called. Thomas, a man with a significant criminal history, faces a brand new, serious charge: aggravated assault with a deadly weapon, a second-degree felony. Without hesitation, he pleads guilty. Judge Boyd swiftly sentences him to 8 years in prison for this violent act, a consequence that alone would reshape his life. But this is only the beginning. The core of the drama unfolds as Judge Boyd pivots to 2 prior cases where Thomas was already on community supervision for being a felon in possession of a firearm. In both cause numbers, the state alleges the same devastating violation. He committed a new offense. When Judge Boyd asks for his plea to these allegations, Thomas can only utter a quiet "true." This admission triggers Judge Boyd's powerful rebuke. Looking directly at the defendant, she delivers the crushing assessment that defines the hearing. It appears to the court that you have learned nothing. This statement isn't just commentary. It's the prelude to a judicial demolition. For the 2023 case, she grants the motion to revoke, finds him guilty, and sentences him to a staggering 10 years in prison. Without pause, she moves to the 2022 case, revokes his probation there, and adds a 6-year sentence. Crucially, she orders all sentences, the new 8 years and the revoked 10 and 6 years, to run concurrently, meaning he faces the longest single term, a decade behind bars. Judge Boyd's actions are a masterclass in judicial efficiency and stern authority. She systematically dismantles any second chance Thomas had been given, constructing a prison sentence that reflects the gravity of his choices, continuing to carry weapons and engage in violence while the justice system had offered him supervised freedom. This is not just a sentencing. It is a definitive statement that repeated chances are exhausted and the full weight of the law will now fall. The drama lies in the cold, procedural execution of consequences, culminating in Judge Boyd's devastating verdict on Thomas's character and future.